Providing your potential buyers with insight and information into the legalities of the home buying process is one of the more complex components of the job. Yet, real estate agents need to fully understand all components of the process, including terminology such as deed of trust. What is that? How does it impact you as an agent? Most of the time, home buyers will use a loan to purchase a home. Most people don't have hundreds of thousands of dollars they are interested in spending to buy a home outright. Hopefully, once a buyer comes to you, he or she has already obtained a loan. If not, it's important for you to encourage them to do so, simply because you need to know how much of a home they can afford to buy. Here's a bit of clarity before we get into the details. The term mortgage, or deed of trust, refers to a document that the buyer signs. A loan is the actual financial transaction and money owed that must be paid back. As a real estate agent, one term you'll likely come into contact with is deed of trust. There are slight differences between a deed of trust and a mortgage, and your buyers will want you to explain those differences. What is a deed of trust? Let's break down what a deed of trust or trust deed is, how it can apply to the transaction, and what it means for your buyers. Let's step back a bit. When your buyer finds the house he or she hopes to buy, they will work hand in hand with their lender for the financial component. As an agent, you may be asked a few questions about the loan itself, but it is never your place to actually offer financial advice. Many real estate brokerages handle the title search and processes, while the lender handles the legalities regarding the loan itself. The legalities of the ownership of the home, once bought, are complex. What's important is for your buyer to realize that they do not outright own the home until they pay it off. In the process of doing so, the promise they signed, the mortgage or deed of trust, truly holds the ability to reclaim the home if they fail to make payment on it. When your buyer obtains a mortgage or deed of trust, he or she is signing a basic IOU to the lender. They promise to repay the money borrowed. These documents pledge not only that they will repay, but that the property is used as the security for the loan. This becomes important should the buyer fail to make the payments and enter into foreclosure. This document gives the lender the right to foreclose and take ownership of the property. That's why it is so important that your buyers understand what they are entering into. What are the differences between a deed of trust and a mortgage? We need to take a closer look at the differences between a mortgage and a deed of trust. This is important. Many times, home buyers will come to you and ask about a deed of trust. They may wonder why their lender is talking about a trust deed, or why they have to sign this document titled Deed of Trust. Most of the time, people associate trusts with wills or with savings planned for a wealthy family. However, there are various forms. Trust deeds are complex documents, and they do impact the way your buyer will own and maintain his or her loan. So, what's different here? Some states use mortgages and others use deeds of trust. Some use both. You should know what your buyers in your state will likely encounter so you can provide the proper explanation to them. We'll get into more details about when this applies in a few minutes. Who is involved in a deed of trust? The deed of trust involves several people that are involved in it. The trustor is the borrower, your homebuyer. The beneficiary is the lender, whoever the homebuyer decides to work with. The trustee, this is a third party. This party owns the actual legal title to the property. If your buyer defaults on the loan, the trustee will sell the property at an auction. Remember, this benefits the lender, not the buyer. Sometimes, the trustee is an escrow company. To see some of the difference between a mortgage and a deed of trust, consider the parties involved in a mortgage. The mortgager, again this is your home buyer. The mortgagee, the lender. That's it. There's no third party involved here. How can you explain this to your buyer? Even though people often call their home loan a home mortgage, it's technically not. By legal terms, the mortgage is actually this piece of paper that your home buyer will sign. Your home buyer will sign a mortgage document and give it to his or her lender. When they do this, they create a lien on the home. When a buyer asks you to explain this, it's important to be clear. Once the home buyer secures the money to purchase the property, the lender will take steps to protect that loan. The mortgage and deed of trust will help them do just that. For example, if you wanted to loan your friend $2,000, but you needed those funds to be repaid to you, you may ask for the title to his or her car. While legally without a contract this may not hold up, to your friend, it's enough to ensure they repay the loan. And, if they don't, you seize the vehicle. Lenders have to protect their investment in the property. They do that through the actual mortgage or trust deed document. To further explain the differences, consider this. There are two main differences. The first is what we've already discussed: the two parties involved in a mortgage and the three that make up a deed of trust. The second difference is in the way the lender takes action if and when your buyer defaults or doesn't pay for his or her loan. Now, let's break down what your buyer can expect here. What happens in a deed of trust state when a home buyer takes out a loan to buy a home? As noted, the deed of trust is a lien on the collateral, the home, that provides security to the lender. At this point, your buyer has secured a loan and qualified for it through an initial pre-screening and credit check. The lender has offered the loan to the buyer. You've worked with your buyer to find their dream home. You're happy, they're happy, and now you want to close the deal. There are legal filing requirements with all deed of trust documents. These will differ from one state to the next. This is a legal document that must be filed with the court system as well as made public. Yes, this means anyone can get a copy of the deed of trust. That's not much different than a traditional mortgage, though. Here's how the process unfolds. The lender agrees to move ahead with the loan closing. The loan goes to underwriting. That's the process in which the lenders and backers work together to ensure the borrower is a safe bet. This can take several weeks. Once the underwriters approve the process, the loan moves towards closing. The home buyer will sit down with a representative from the lender or with a third-party title agency. This signing process includes many of the details of the loan, but it also includes all information about the deed of trust. Encourage your home buyers to read it. In some cases, real estate agents can, and may wish to, be present during the property closing. However, This is a transaction between your buyer and their lender. Then, we need to record the deed of trust. The buyer doesn't have to do this him or herself, and neither does the real estate agent. First, state laws will require the lender to hold a copy of the deed of trust for themselves. This is always accessible to the borrower as well as to other interested parties. The trustee will file the deed of trust document with the court system. As you will see later, the trustee holds a great deal of power throughout the ownership. Most often, the deed of trust document is filed with the county recorder's office. Some states have different terminology for this. Finally, at this point, keys are exchanged and the transaction is complete. What happens in the event of a default? It is important to be able to explain the foreclosure process to your buyer. Most people have an opinion or thought about foreclosure. Your clients have likely had friends who lost their home through foreclosure. They've seen the news reports of homeowners being kicked out of their homes as a result of the big bad banks. Yes, it is heartbreaking when this happens, but it is also legally justified in most cases. Here's the bottom line. When your buyer is sitting in front of you ready to buy a home, they are thinking about the layout, the backyard, and what color to paint the interior. What you need to ask them is whether or not they are confident they can afford the monthly loan payment. Sure, this isn't your legal requirement, but real estate agents are often indirectly connected with the loan. If you sell them a home and they cannot pay for it, they will indirectly blame you. That aside, you also need to explain foreclosure to your buyers when they ask about it. Some may say, "I've heard the market is too risky and banks are foreclosing on buyers." Or in some areas, the view is much harsher. "I don't know if I want to buy. I know banks are taking back homes from people right from under them." In a deed of trust case, this process is a bit different than with a mortgage. Here, the court isn't used directly. It's bypassed. This is called a non-judicial foreclosure. And that also means it is far more affordable and a quicker method to resolving the situation. It means the court does not oversee the procedure. On a side note, some states will have a requirement that a judge will sign off on the foreclosure. To be blunt, non-judicial foreclosure, or foreclosure with deed of trust documents, favors the lender, not your buyer. What happens during the non-judicial foreclosure? Let's say your homebuyer finds him or herself facing foreclosure. In a non-judicial state, they may have very limited time to take action. There's not usually very much time required for giving notice of a pending foreclosure. And, once it does happen, most homeowners have little ability to get out of it. Here's a brief overview of what will happen in this situation. We will go into more detail about non-judicial foreclosure in a later chapter. However, to understand the deed of trust, you need some info. The borrower missed a payment, and the trustee sends a letter to the borrower of the missed payment. If the borrower fails to make payment in the given time, the trustee lists the property for auction. The trustee auctions off the property and, if not bought, it reverts to the lender's ownership. Some states allow the borrower to redeem the property by paying all fees and all that's owed within a specific time frame after the sale. Let's create a visual for how this might happen. Mr. Smith is your client. He buys a home with your help. The transaction is in a state where deeds of trust are used. He secures a loan, obtains the deed of trust when the property is sold, and starts making payments to the lender. As an agent, your job is done at this point. 6 months later, he's missing payments for some reason. He may have lost a job, become ill, or just didn't manage his money wisely. With a deed of trust, the trustee sends a notice, usually within 30 days of missing his first payment, of a notice of default. Soon after, sometimes just a few days, a notice of sale occurs. Now, many times, lenders will start calling borrowers the day after a loan payment is missed. Some even offer to work out payment arrangements or will accept late payments. A borrower that ignores those calls is one that is going to see these notices occur much sooner. Once Mr. Smith receives the notice of sale, he has very little legal opportunity available to him. Remember, he can't buy time or delay the proceedings since the court isn't involved here. The trustee handles it all. He should invest the time in speaking to the trustee to see if they will accept late payment to reinstate the loan. Sometimes they will not offer this. The trustee holds the auction to sell the home. The homeowner has to vacate the property. Mr. Smith sees the home sold at auction, but still has the right to redeem. Mr. Smith works to secure the additional fees along with the loan payments he missed. He's able to meet the conditions of the right to redeem. That means Mr. Smith will maintain his home, and whoever purchased it at auction loses any claim to the property. What is your role as a real estate agent? As noted earlier, most real estate agents don't have to worry much about these proceedings, unless they are working with a homeowner who is trying to sell the property prior to defaulting on it. As an agent, you do not want to encourage someone who cannot truly afford a home to make a purchase, even if that is contradictive of creating a profit for you. It's better to ensure they understand the risks of foreclosure from the start.